Thank you, Mr. Chairman. I appreciate you both being here. I tell folks back home, best part of my job is that the subject matter experts come up to the Rules Committee every Monday afternoon, and I get a private tutoring session on what's going on. And I get to respond to all the internet myths that have been mailed to me all weekend long about whatever the process is. And I've got one, and I hope you can set me straight. One of my constituents wrote in and said, Rob, is it true that the House is getting ready to use a 1930s piece of legislation designed to regulate telephone monopolies and apply that to the 21st century internet in the name of promoting innovation? Is that true?
One of your constituents wrote you that, huh?
You can see the folks back home that I have.
I have a little skepticism about that.
You should see them.
That's not true. And the reason that's not true is all the parts of Title II that applied to the old Ma Bell and telephone, those were all the provisions of Title II that were forbeared in the bill permanently. So none of this 1930s Ma Bell brick telephone that we hear about so much is really part of this bill anymore. Those are the sections that have been forbeared, and they've been forborne permanently.
Mr. Ladd, is that...
Well, this is where we have a difference of opinion, because up until a few years ago, FCC commissioners, chairman, they all saw what you're looking at with the internet as an information service and not a telecommunications service. And so not under Title II. And at the same time, when you go back to the '96 Act, what really wanted to make sure that more money was going to be out there, that things were going to really proliferate for the better for the consumer, is to make sure you had it, a very, internet that was not going to be under Title II. By putting it under Title II, then you're putting it under the restrictions from, the 34 Act, which is then, of course, you're going back to the days of Ma Bell and all those when you're looking at on the monopoly side. And that's not what the internet is. It's an information service and not a telecommunications service. So it really comes down to that again, we want to make sure that it remains open, that folks have the ability to, get on there, to innovate. And again, that's what's grown the internet. It's not the government. It's been on the private side. And so we want to make sure that that continues. And, when we're talking about the forbearance, and I'm not sure if it's been circulated yet, but if it hasn't, I'd like to ask unanimous consent that it is. This is a Congressional Research Service dated April the 2nd. And it's really dealing with the questions on the forbearance of the 700 areas. Thank you. I appreciate that. But just to, again, we have disagreement again on where we are on this right now, but it says for reasons discussed in more detail below, the memorandum concludes that review in court would appear likely to uphold an FCC interpretation that H.R. 1644 does not abrogate the FCC's authority to revisit prior forbearance determinations, including those made in the 2015 order. So again, we want to make sure that we go back to where we saw commissions, Republican and Democrat, saying that this is an information service that's being provided out there.
Now, all I have, Mr. Ladd, is just these 4 pages of the Rules Committee print. Where is that list of the 700 some odd provisions that one expected to be applied, but now through the committee's benevolence are not going to be applied?
Well, thank you. And what we've asked is that we could get those 700. Those have not been given to us. And one of my amendments is asking that that no later than 3 days after the date of the enactment of the Act, that the 700 rules or regulations referred to in paragraphs 5 and 37 of the report, are provided to us. And so we don't have those.
But there would be no reason not to provide those, is there, Mr. Chairman?
Let me say this, 2 things. The CRS report that you just put into the record does not apply to the bill that's before you. That applied to a previous version of the bill, and the bill has since been amended to address some of the concerns on forbearance, and there is no CRS report on this bill that's before you right now. So what's in the record does not apply to the bill before you. Secondly, I find it rather interesting. This is my 25th year in Congress. I never knew that we legislated based on what bills don't do. but rather on what they do. We have been talking all along about what this bill does and how it affects ISPs and how it affects consumers and those protections. The fact that over 700 regulations that were formerly part of Title II are no longer in this bill. They've been forborne. And someone has, apparently, this has been referenced, by the way, not only in the 2015 order, but amongst FCC staff and amongst Mr. Latta in a statement he made back in February where he said there's over 700 regulations for bear. So now the question is, apparently the FCC never compiled the list because I don't think anybody was too much worried about what didn't apply anymore, what wasn't in law anymore, what they didn't have to worry about anymore. Seems a kind of a silly thing, but I have no problem at some date if the FCC wants to sit down and compile the 700 regulations that no longer have anything to do with this legislation or Title II. Let them have at it. You know, I don't care about that. But just to be clear, it's really a non-issue in terms of the effect of this bill.
I think from my constituents' perspective, it's that the internet is the goose that's laying the golden egg, particularly all across rural Georgia, where we're connecting folks who've never been connected, offering economic opportunities that have never been offered before. And I don't know how it is back home for you, but I'm from the federal government. I'm here to help in an area of high innovation and emerging technologies. Doesn't fly so well back home. So those regulations that are not going to apply from the 1930s Ma Bell days, meaningful to folks back home. Now, what I have heard, thinking about what the bill does do, is from a lot of folks worried about the search engines you mentioned earlier, Mr. Latta. Folks worried about we've seen the stories about conservative content getting pushed down, about folks being silenced because people didn't like the content of their free speech. I think in the monopolistic environment that some of those services are rolling into these days, there may be a role for regulation. What does this bill do to protect folks from being silenced, as we have read stories? What does it do to deal with those service providers on the search engine side, for the Twitters, for the Facebooks of the world?
The edge providers. This bill's narrowly focused on ISPs because they're the gatekeepers to the internet. They control the networks and they have the ability to shape and control traffic. The FCC has no authority over edge providers or expertise in this matter. They're regulated over at the FTC. So I'm sympathetic to some of the things that have been said about edge providers and the need to maybe look into that. But that's another issue for another day. It doesn't belong in this bill, but I am looking forward and happy to work with my friends on the other side of the aisle on looking at edge providers at a future date. It's just not something that belongs in this bill.
Well, you know, if I could comment again, I'm sorry, if I may. Again, as I mentioned earlier, you know, when you're looking at your edge providers out there, and that's where we're hearing the concern from. It's from, you know, who's doing the blocking, who's doing the throttling, who's doing the pay prioritization out there. It's not coming from the ISPs, which this bill has the control over. It's on the edge providers, which is, again, your Google, your Twitter, and your Facebook. And so that's why we think it's very, very important that you do look at it in this, because you got to see where it's happening. I know that Dr. Burgess has an amendment, I believe, that has a very holistic approach on it.
I know we've been talking about this issue for what seems like my entire 8 years in Congress in one fashion or another. I believe the Energy and Commerce Committee has as many talented folks as we have anywhere in Congress to sort this out. I recognize what the chairman is saying when he says he expects folks to come to him, because that's what folks do when folks have gravitated to power. Perhaps that's why I hear the things I hear from my constituency back home. Hey, they did it that way, so we're going to do it that way. My constituency believes we can probably all do it a little bit better, and I hope that they're right. I yield back, Mr. Chairman.